All right, let's see. We hit the Let's Go Live button. Looks like it's connecting. All right, cool. I think we're good. All right, what's going on, guys? Happy Wednesday. Hope you're all doing well. So we got a lot of stuff to cover today. I don't think we're gonna get through it all. Hopefully the audio is better. Some of you guys said the audio in the last one was kind of weird, which is funny because I never changed the audio settings. It just kind of does whatever it wants to do. So chat's open. That's acting funky today too. It asked for some kind of update, and now it's not connecting exactly right. But it's there. If you guys have questions or anything you want to talk about, we can get into that. So if you remember from the last one, or most of what we've been talking about is the WFG versus GFI and the Olsons. And so that's been our main focus. They're kind of trying to consolidate all of that into California. But what we haven't been looking at is the other side of that, which is Sandra and Eric and GFI suing WFG. Now, that's what we're going to kind of focus on. We got a little bit behind on that side, so we're going to go back and watch all of that. And their main topic that they're talking about now is arbitration. We'll get into that. We've got three different, so if you understand the legal aspect of it, it kind of gets stacked. So there's a motion to do something is by one party, then the other party gets to do what's called a response, and then the party who started it gets to do a reply. So it's kind of like a sandwich almost, right? And so we've got all three of those for this arbitration, this motion to do arbitration. So WFG filed the motion to do arbitration, then we have the response from GFI, and then the reply from WFG. Now, I don't think we're gonna be able to get through all of that today. We'll probably have to split some of that off to Friday. Now, the cool part about some of this too is that they also put the contract for WFG, so that's public record now, so we can spend a day and kind of go through that. They have the whole thing. It's like 100 pages long. The contract's like 20, but then they have all the other stuff that you get when you do your enrollment, when you become an agent, so we can kind of look through all of that. We'll probably need a full session to be able to do that. They also put GFI's contract, which we already had. All of that stuff is over on Locals. So if you're not on Locals yet, go check that out, McKenzieLong.locals.com, and we have all the documents over there. A bunch of it, as much as I can do, is unpaid. You just got to kind of search to see what you have access to. But those kinds of things like the agent agreements are over there with no cost. You can get access to those. The court filings do have a cost. We had some people, the Life 180 guy was taking a lot of this stuff and making up his own stories about the court cases. So we kind of had to put it behind the firewall, which is why it's over on Locals, because we got demonetized over here on YouTube. And I appreciate you guys. You guys have been doing a fantastic job on helping to share, like, subscribe, do all that stuff. I appreciate you. Don't forget to hit the bell because they are not putting out notifications about most of my content. We went from about 10,000 views a day to about 500 views a day with this whole process of being demonetized. So they're not sharing this information like they normally would. So that means you've got to be a little bit more proactive on it, and it is what it is. But all these documents and stuff are over there on Locals if you want more information. I appreciate your support and all of that. So let's get into it. I appreciate you guys being here on this Wednesday. Hopefully you guys are having a great week. It's been absolutely beautiful out here. So we're talking about arbitration, and arbitration, to kind of give you an idea, let's talk a little bit about why it's important, what it is. So arbitration is supposed to keep everything outside of a lawsuit. And it's used a lot of times if you're in most types of, if you work for a large company, if they have any type of a union. I know my UPS clients oftentimes have to go through arbitration. Most of the time, if you're working in our industry in real estate, it goes through arbitration. And so what arbitration is, if you have a dispute, instead of going through the legal system, which takes years to actually get resolved, arbitration is supposed to be faster. It's kind of, I had to go through it. I was working for engineering, I was doing engineering for the county. I had some disputes about some things at work and had to go through this arbitration process. So the good side of it is that it's faster. You can just put everybody into a room, put the arbitrator in there, maybe a couple lawyers, and you can get it knocked out pretty fast. The bad side to it, at least in my opinion, it felt like it was heavily weighted towards the company when I was there. It was in their offices, they provided lunch, they took the arbitrator out. It's just seemed very kind of biased when I had to go through that. So the benefit kind of leans towards the company on that, and oftentimes in arbitration, they're not going to do any kind of, usually any kind of, what do you call it, where they pay out any type of thing. So generally speaking, it's more, hey, I think I was wrongfully terminated, and then they get to kind of present their case. You present your case, the arbitrator decides, and then maybe you get your job back or not. But what they're not going to do is provide a lot of damages, which is obviously what Eric wants and needs. So those are kind of the two weighing aspects to it. So we're going to see WFG's side, they're wanting to go into arbitration. As an agent, if you're with WFG or GFI, you sign that you want to, or that you are, that you're supposed to go through arbitration. That's part of the contract. We actually have Sandra's, so we'll go through that as well. If you didn't know what you signed, if you're WFG or GFI, at least that way you can kind of see what it is to be in arbitration. So let's hop into it. I know that was a long explanation, but I kind of want to give you an understanding of why we're at this point and what's going to happen with that. So WFG is asking to obviously get into doing arbitration. And so we'll start in this aspect. And this is, we're a little bit behind on these. This was from the 22nd, so we're almost a month behind on these. But the nice part is we can knock them out pretty quick. There hasn't been a lot of movement on these. And this is from the court, the court documents of the case that ends with 00477, if you're keeping track on any of those. But again, this is going to be Sandra and GFI, and they're suing World Financial Group. Okay, now this is WFG's motion. They're the defendant, right? And so their motion to compel arbitration. We're going to read why they want it and what exactly they kind of expect. So they've set some stuff up. This is supposed to happen on May 2nd, so coming up here pretty quick in courtroom 4, if that holds. If you guys were here for the other one, we were supposed to attend one of them, and they ended up making the decisions outside of the court to kind of go through that. So let's look at what they have to say, and then we'll be able to look at Olson's response. So points of authorities, and we're going to kind of breeze through these pretty fast because a lot of you guys are familiar with the story and they're kind of reiterating some of these things, but we'll go through it as quickly as we can, and I'll try to keep my commentary to a minimum. So basically, she's Miss Olson is a former insurance agent and current co-founder of GFI, right? She entered into an independent contractor agreement with WFG, which we'll go through that probably on Friday. I think we can go through, it might have to be Monday, but we'll get into that at some point so we can see everything about the agent agreement that was released, so we can go through those and use the platform for the sale of life insurance products. She originally contracted back, or as recently contracted in April of 2023. Basically, she re-signed her contract, which is a mutual agreement to arbitration claims. We'll get into the arbitration agreement in our in WFG's contracts or GFI. If you're in the industry, you have signed an arbitration agreement in most cases. So the agreement includes broad arbitration clause, states that any claims related to parties' relationship, whether sound in contract or tort, must be subject to mandatory arbitration. Arbitration agreements contains a narrow exception allowing for parties to seek emergency injunction relief, whether temporary or preliminary, in a court of competent jurisdiction pending resolution of that arbitration. Here, Ms. Olson has asserted claims for declaring relief, restraint of trade, tortious interference with prospective economic advantage and unfair competition. Ms. Olson's claim falls squarely within the arbitration agreement's peer view. Because Ms. Olson's claims are subject to binding arbitration, the court could dismiss this action. Alternatively, the court must issue a stay pending arbitration. Stay just means that they're going to move forward with it, that it's going to keep going. Pending arbitration would dismiss that action, or they're going to just stop that one to continue with arbitration. So factual background, they signed in the contract, and we'll go through this in full, so we're going to skip this part of what that looks like. You're welcome to screenshot that if you want and kind of go back and read it, but we'll go through the full thing on what she actually signed. Ms. Olson has asserted her claims and her relief, restraint, therefore mandates Ms. Olson claims to be subject to abiding arbitration by the federal government. Procedural background, so obviously this is reiterating on the 25th, she sued WFG, and WFG had sued her, so the actions are properly brought in the court system and outside of the arbitration, so she's doing it outside of arbitration instead of going through the arbitration process, which is what they're saying that she should be doing. On the 26th, the defendants in WFG's action removed the action to federal court. After the court rules on WFG's request for interim injunction relief, WFG's action intends to have its claims against Mr. and Mrs. Olson proceed in arbitration. On the 5th, they commenced an instant action against WFG. On the 26th, Olson sued WFG in the Northern District of California. On the February 26th, WFG filed motions to compel arbitration in this action and Mr. Olson's action against WFG. Rather than oppose WFG's motions to compel arbitration on March 11th, Olson filed a First Amendment complaint. So a lot of times when you do an amendment, it kind of resets everything because you're changing things inside of that. So they're basically kind of giving a timeline of what's been happening. Also on March 11th, WFG's through counsel sent a letter to the plaintiff requesting a meeting to confer and initiate a process of arbitrating their dispute and selecting an arbitrator as of the date of filing of the motion. Plaintiff, this would be the Olson's counsel, has not responded or even acknowledged that demand. Probably because they don't want it to go to arbitration, and fairly on their side is that it's very unlikely to get any kind of damages. It's very unlikely to get anything other than maybe your job back or your position back. That's really about what the arbitrations are. It doesn't mean that it doesn't happen, it's just fairly rare. So while the court has not expressly removed WFG's initial motion to compel arbitration from the docket, WFG resubmits the motion targeting Ms. Olson's First Amendment complaint. The current action should proceed in arbitration for the reasons set forth. So these are the reasons why they're saying it should go to arbitration. So according to this particular rule, presents the following issue to be decided. 1, whether arbitration can be compelled to each of Ms. Olson's claims. So if each one of her claims falls inside of what arbitration can handle, then it should be handled by the arbiter. Number 2, if Ms. Olson's case should be dismissed or stayed, then that has an impact on whether it goes to arbitration or not. Ms. Olson's claim must be compelled to arbitration. Ms. Olson's claims to be resolved in binding arbitration and governs the adjudication of Ms. Olson's claims. The court therefore should dismiss the action pending the resolution of dispute in abiding arbitration or in the alternative stay of action. Oh, you guys can't see that far up. I'm going to scoot that down. Stay action pending arbitration. Ms. Olson's claims are subject to binding arbitration. They're going to go through a bunch of case law and kind of say, hey, in this particular case, this happened, similar areas, things like that. A valid agreement of arbitration exists, meaning that she's signed the agreement. She knows that she signed it. Her signature is on it, which we'll see that here in a little bit, which is very, very different than if it was just a verbal agreement or something like that. But she knew it was in place. She signed it, which brings up another question, right? If they can send out every year and you have to sign it to keep your position and they change things in it, what kind of happens at that point? I don't know. That's where it gets kind of questionable, but this has always been in it. As long as I've been in the industry, there's always been an arbitration clause in it. It's common in most jobs, so it's not like it's something that's really unique. So second is there's no dispute that an arbiter agreement had lawful purpose. The prompt and effect resolution of disputes in arbitration, more case law. I know we're skipping a bunch of this, but this is all case law stuff where they're just saying, in this case, this happened. Finally, the arbitration agreement is supported by valid consideration, the parties' mutual promise to arbitrate any dispute, which is what you sign in that arbitration agreement. So the arbitration agreement plainly covers this dispute. So they're saying that everything that Ms. Olson is claiming for falls inside of what an arbitrator can actually resolve. So they want to be able to do that. And they're kind of repeating themselves here. Specifically, the arbitration agreement states that parties mutually agree to use an abiding arbitration to resolve all disputes that might arise out of or relate to relationship with WFG. inside of that arbitration agreement. Finally, the arbitration agreement states the scope of this agreement includes all disputes, whether based on tort, contract, or statute as allowable under applicable laws. This includes any claims, whether they are based on state or federal law or regulations, equitable law, or otherwise. Any doubts concerning the scope to arbitrate these issues should resolve in favor of arbitration, whether the problem at hand is the construction of the contractual language itself or an allegation of waiver, delay, or like defense to arbitrarily. So basically, they're saying that this should supersede. Somebody had messaged me earlier and they said, well, why don't they just put in the contract, like GFI could just put in the contract, well, you have to dispute everything in the state of Wyoming, right? Or WFG could say you have to dispute everything in the state of Georgia, and then it follows under their laws. I don't know exactly how that works since we're able to operate in so many different states. Right, like you can live in one place and operate around the country now simply because of Zoom. It's not like you would just, 20 years ago when you would only really talk to people in your town. Now you can literally talk to anybody. So it falls into different jurisdictions, and that's kind of what arbitration is supposed to take care of a little bit of that aspect. So covered under contract containing an arbitration clause, all doubts to be resolved in the favor. So basically, if there's any doubts if arbitration can handle it, it should go to arbitration to figure that out. It shouldn't go to the court to be able to do that. The standard for demonstrating irritability is not high. In the absence of any express provision excluding a particular grievance of arbitration, only the most forceful evidence of a purpose to exclude the claim from arbitration can prevail. So they're saying in most cases it should fall into arbitration. Plaintiff First Amendment complaint seeks to declaratory judgment, injunctive relief, and monetary damages. However, nothing in the First Amendment complaint seeks interim relief to preserve the status quo as permitted by the carve-out of the arbitration agreement. Arbitration agreement and the interim relief is not necessarily for the plaintiff claims as made evident by the plaintiff's conduct in this litigation to date to motion for temporary restraining order or preliminary injunction is pending or has been filed. So they're saying none of that stuff is waiting. In this particular case, you remember the temporary restraining order, that was in the other case. So that's why it can get a little bit confusing looking at multiple cases at the same time. Mr. Olson's claims are based entirely on the relationship between the parties and sounds in contract. So it would be different if somebody broke the law, right? And this is where we're getting into a lot of these questions of this is really a dispute between two business people. And so that can be handled by arbitration. When you get into fraud and things against the law, then that starts to go into the court system. But this is a relationship between two parties that they can resolve basically, or what they're saying they can resolve through arbitration. The Federal Arbitration Act governs this dispute. They're talking about the agreement again, kind of referring to some of that. Some case study, we'll go through and actually read that arbitration because we're almost finished with this. Represents the liberal federal policy reserving arbitration agreements, more case laws. So according where the contract contains an arbitrary clause, the obligation to arbitrate a dispute should not be denied unless it is said with positive assurance that the arbitration clause is not susceptible of any of the interpretation that covers the assertion dispute. So if it falls outside of the arbitration, then that's when you would look at doing something in the courts. However, they're saying that that is not happening here. Doubt should be resolved in favor of coverage. The court should dismiss or stay this proceeding pending arbitration of Ms. Olson's claims. Because Ms. Olson's claims should be resolved through binding arbitration, WFG respectfully submits that the dismissal of this action as to Ms. Olson is appropriate, whereas here all the claims are subject to arbitration and there is nothing left for the court to resolve once arbitration is completed. Dismissal is necessary. And they're going to go through some more case law to be able to do that. Conclusion, for the reasons stated above, WFG respectfully requests that this court compels the parties to go into arbitration. So let's look at what WFG agents actually sign, and we'll kind of run through this. So you can see here, this is the mutual agreement that they have listed. This is what Ms. Olson signed, and we can kind of see what it says, and you guys can kind of determine if you feel that it should fall into the aspect of going into arbitration. So this mutual agreement to arbitrate claims agreement is entered into between WFG, the insurance agent, formerly known as World Financial Group Insurance Agent, and each undersigned agency, and me. WFG and I agree to use abiding arbitration as the means to resolve all disputes that may arise out of or relate to my relationship with WFG, including but not limited to any determination of my classification as an independent contractor. WFG and I each waive and relinquish our respective rights to bring claims against the other in court, and this waiver will be equally binding to any person who represents or seeks to represent WFG or me in a lawsuit against the other in court. WFG and I agree to submit any claim, dispute, and or controversy against the other binding arbitration under Federal Arbitration Act. This includes any such claims against WFG's brands, concepts, affiliates, subsidiaries, parents, related entities, owners, directors, officers, managers, employees, or agents. So kind of covers almost everything needs to go through that arbitration. WFG and I agree that these rules apply to this agreement. WFG and I also agree to the scope of the agreement includes all disputes, whether based on tort, contract, or statute, as allowable under applicable law. These include any claims whether they are based on the state or federal law or regulations, equitable law, or otherwise. However, WFG and I agree that the court may grant interim, temporary, or preliminary injunctive relief, preserve the status quo to prevent material imminent harm pending arbitration, except as stated wherein WFG and I agree to give up our respectful rights to trial by jury of any claim we may have against the other that may arise out of the relate to my relationship with WFG, contract or otherwise. This includes any such claims against WFG's brands and etc. So pretty standard, same thing you would see. Most of you, if you've worked any type of job, you would see something similar probably in your contracts for your job as well. Only applies to those operating in California. So California has its own special rules, so a little bit different here. WFG and I agree that this agreement does not prevent me from filing or pursuing proceedings before the Department of Industrial Relations under the Labor Code section. However, WFG and I pursue a de novo review of an order from the DLSE. Those claims should be subject to this agreement. WFG and I agree that arbitration in this is the exclusive remedy for all disputes. WFG and I bring all claims brought under this agreement in an individual capacity. So there's, again, saying everything that any type of dispute that they have should be handled through this arbitration clause. So it sounds like thus far they kind of have the upper hand on wanting this to go to arbitration, which would kind of be bad for us because I don't think we would see anything. Nothing's going to be filed on the docket, at least for that particular side. Good for WFG to kind of go through that. Maybe not as good for GFI because it's going to be a little bit more, it's going to be less vocal. It's not going to be as much out there. Probably won't get a lot of damages if that's what they're trying to collect. So class and collective action waiver, WFG and I agree. This agreement eliminates my ability to bring or participate in class or collective actions, except as stated herein. No one has the authority to construe this agreement or allow or permit consolidation or joiner of other claims and controversies, including any other agents, contractors, persons working with WFG, or permit such claims, controversies to proceed as a class, collective, or similar representative action. By signing this agreement, I'm agreeing to waive this substantive and procedural rights I may have to sue on class, collective, and representative basis. No court or arbitrator will have the authority under this agreement to order a class, collective, or representative action to proceed in arbitration. To the extent allowable under applicable law, WFG and I agree this agreement does not allow or permit claims brought on behalf of any state or government as any private attorney general. to the extent allowable under applicable law, I agree to waive any substantive procedural rights I may have to sue as a private attorney general. No court or arbitrator will have the authority under this agreement to order claims brought on behalf of any state government or any private agency. I don't think this really applies as much to proceed in arbitration. WFG and I agree that a court of competent jurisdiction will be the sole determiner of any disputes regarded to this agreement that allows class, collective, or representative arbitration. The court of competent jurisdiction will decide all issues about the enforceability of the class, collective, representative, private attorney waivers within. The arbitrator has no authority or jurisdiction regarding these issues. WFG seeks enforcement of class, collective, representative, or private attorney general waivers herein. WFG and I agree that a court should dismiss those claims without prejudice to the extent allowable under the applicable law. So sounds like they have a pretty clear-cut case as far as that goes in the contract that we signed. Now, obviously, part of GFI's thing is saying that these are all restrictive covenants. We shouldn't be entering into any kind of contracts like this. So they didn't. We'll have to see if they claim something like that in their reply to WFG. If that's going to be kind of their argument, is that, well, all of that should kind of be void. There shouldn't be any kind of agent agreement. We'll see if they kind of go that route. So if a court determines that the prohibition on class, collective, representative, attorney general actions are invalid, WFG and I waive the right to arbitration of the class, collective, representative, and attorney general actions. Instead, WFG and I agree that such claims will proceed in a court and not before an arbiter, but only after WFG and I arbitrate any claims subject to this agreement. So it's got to go through arbitration first. If for whatever reason they cannot resolve the issue, it's outside of their scope, then it goes through the arbitrator first, and then it can go into the court of law if necessary. But that's kind of got to be the first line of action, is what is signed on in the contract. WFG and I agree that a court of competent jurisdiction will be the sole determiner of whether FAA applies to this agreement. Besides any other requirements imposed by law, the arbitrator selected will be a retired judge or an otherwise qualified individual to whom WFG and I agree. The arbitrator will have immunity of the judicial officer of civil liability when acting in capacity of the arbitrator, which immunity supplements and other existing immunity. Only applies to the operating outside of California, so rules are a little bit different. All federal rules pleading, including to the right to file a motion to dismiss, all federal rules of evidence, all rights to resolution to dispute by means of summary judgment, judgment on pleadings, and directed judgment or non-suit shall apply and be observed. Likewise, WFG and I agree to consider and treat all communications during or in connection with the arbitration process as privileged, meaning that it's between them. It's not going to go outside. So part of the nice thing for arbitration for businesses is that a lot of the disputes don't get out into the world. We can't really do what we're doing now. The two of them have to sit down, go through the arbitrator, and do it. Whereas when it goes into a lawsuit and they create a docket, all of this stuff becomes public record, which is probably not as good for the company to be able to have that out and about. Versus if you're doing it in arbitration, it's kind of behind closed doors. It's like taking the two kids, locking them in the room with mom, and they have to resolve it there, versus them going on the internet and complaining to everybody about what's going on. So only applies to those operating in California. All California rules of pleadings, including the right of demur, all rules of evidence, the rights to resolve of the dispute by means of summary judgment on the pleadings, and judgment under the civil code procedure will apply and be observed. Likewise, WFG and I agree to consider all treated communications made in good faith, contemplation of during or for the arbitration process as privileged under the code. So again, the conversations that we're having, kind of similar to what Olson just put in place on the other side, the protective order, right? So they're saying certain things are going to be privileged. So any communications that we have, any disputes that we have, you're not really supposed to share that stuff with the public. It's going to be between us. As reasonably required to allow full use of the benefits of this agreement, the arbitrator shall extend the time set for giving notices and hearings. Award will include the arbitrator's written reasoned opinion. The arbitrator shall base resolution on all disputes solely upon the law governing the claims and defenses pleaded, and the arbitrator may not invoke any bias, including but not limited to motions for just cause, other than such controlling law. So the person's supposed to be completely unbiased. I agree. Any oral representations or agreements about the dispute resolution procedures do not alter this agreement. If a court finds any word, term, phrase, sentence, provision, portion of this agreement void or unenforceable, this is going to be important. WFG and I agree. The court should sever the word, term, phrase, provision, or portion and enforce the remainder of this agreement. So if it does go to a court and the court finds a particular word, term, or phrase or provision that's used, then they can't throw out the whole thing. They're just going to throw out that particular word, term, or phrase. So the whole contract doesn't become void just because maybe a state law changed or something happened and now that particular word, term, or phrase or provision is no longer allowed. Just that part gets removed. The rest of it should stay intact. Only applies to those operating outside of California. WFG and I agree to hold all claims brought under this agreement in Atlanta, Georgia. So here's exactly what you guys were talking about. Can't they designate it in a particular state? To the extent allowable under applicable law, WFG and I also agree the law of Georgia will apply. So I guess that's where that falls in, is through the arbitration aspect of it, that if you're outside of California, anything, if you make any kind of dispute and you have to go through arbitration, it's going to happen in Atlanta, Georgia, and the Georgia laws will apply. Only applies, so if you're operating in California, that's a little bit different. WFG and I agree to hold all claims brought under this agreement in the county in which the claims arose, or any other county where venue is otherwise appropriate under statute. The arbitrator should award reasonable fees, costs, any proportion thereof, prevailing party, to the extent a court would be entitled to do so in accordance with applicable law. WFG and I agree this agreement is mutually beneficial. WFG and I agree such mutuality constitutes sufficient legal consideration to make all obligations agreed to and within under law. WFG and I agree this agreement controls any prior arbitration agreements that might exist to such extent that agreements conflict. Okay, so if you're in California, this is a little bit different. This is where it's going to get kind of tricky, because obviously the Olsons are in California. None of these other ones matter as much, particularly, at least not from what I can see. But this one says that it will be held under that particular county. So obviously those rules are a little bit different. So for them making the claim about the non-compete or the non-solicitation, that might be helpful for them because they're in California. And this was signed by Ms. Olson back on 4/12/2023, so a little bit more than a year ago. All right, so kind of interesting. I think that's helpful for WFG's case. Let me know what you guys think if you feel that kind of helps them, but it looks like everything's supposed to go through arbitration first. They got to figure it out. If they can't handle it, then it moves actually into the court. So let's see Ms. Olson's reply to that, what they have to say about it. So the first part was why WFG thought we should be going into arbitration. We got a chance to look through that arbitration clause, and we'll go through that again when we can do all of WFG's contract on another day. And then this is going to be Sandra's response to why she does not want to go to arbitration and her feelings on why it should not be moved to arbitration. She obviously wants to stay outside of arbitration. We'll kind of see why that is when we go through her side of the story. There's a ton of case law in this one, so we'll be skipping around. I love a nice table of contents. This is super helpful. We're going to go through some of these things again. I'll try to go through it quickly. They'll talk a little bit about the agent agreement, her starting to work with Mr. Olson, then start WFG stopping recognizing the role of supporting spouses. WFG refused Mr. Olson to sell his code. Ms. Olson created GFI to compete with WFG, but she's saying that the restrictive covenants, them not being able to steal WFG agents and clients, is a restrictive covenant, and that's impeded their business. They should be able to do that. Ms. Olson has been harmed by WFG's restrictive covenants on other agents, and WFG WFG's threats to sue them if they join GFI. I haven't seen that from WFG. Did they actually threaten anybody? The threat was you need, from Rob Day, if you were on the last one, was that you need to be careful, because if you're doing the anchor leg strategy and you're going in and you're taking agents and clients, then you could be sued. But it wasn't merely if you leave the company and go to GFI that you would be sued. So interested to see how she kind of twists that one around too. WFG and Mr. Olson file related actions arising from the parties' dispute. We'll talk about the arbitration agreement, how she feels about it. She says it's not unconscionable. I don't know how you say that, unconscionable, but we'll talk about that. WFG has waived any rights to arbitration by litigation, and get through into the conclusion. So let's dive into that. Lots of case law in this, so we'll probably be jumping around a lot. All right, so introduction. Oh my gosh, this starts off great already. All right, well, there we go. That's good. They took the gloves off. All right. So WFG's motion to compel arbitration is part of its ongoing efforts to appropriate. They are looks like we might have lost something there for a second. So they are oppressors. They stifle competition, and they they know that the agreement is invalid. So all right, good start already. This is going to be good. WFG has separately waived any rights to arbitrate by litigating this dispute in court, including filing 3 different complaints seeking damages and then aggressively litigating its case against Ms. Olson and her husband, Mr. Olson, as well as other former workers arising out of the same factual circumstances. These efforts include moving for a temporary restraining order, which WFG admitted that it knew would fail, and demanding oppressive discovery, which this court denied. I thought they approved. They approved discovery, didn't they? They got granted, which this court denied. Oh, maybe they're saying on this side of the table it was denied, but then they're referring back to the other case that we've been watching. Interesting. Okay. They denied it. I thought they approved the expedited discovery. Okay. I haven't seen that. I don't know what they're talking about there. WFG is using its public litigation against the Olsons as a warning to its workers who want to leave, threatening similar suit against any little agent, quote unquote, who dares to do so. At the same time, which is interesting to me too, because right, they've taken, I don't know, our last estimates were probably around 7,000 or 8,000 licensed agents from WFG. I don't see 7,000 or 8,000 lawsuits, not even close to that. From my understanding, the threat, if you want to call it that, is that if you break your contract and solicit people, then they will obviously come after you for breaking your contract. It wasn't like you quit WFG, move to another company. That happens all the time. People leave other companies, come to WFG, they leave WFG, go to other companies. You're not going to be sued for that. The difference is what your actions are in that process of leaving. So anyway, claims against WFG, which it will impose its unlawful efforts to eternally bind its workers to the company. Wow. So you are never, ever allowed to leave WFG. Once you sign that contract, according to the Olsons, you can never leave, right? What's Hotel California, right? You can check in, but you can't leave. So this make Miss Olson's expend resources in multiple fora and relitigation this court's rulings before a different decision maker, Nothing could be more improper, and WFG's motions should be denied. Okay, first, as a Judge Chen, affirming with the 9th District, found WFG's argument is unconscionable. Okay, oh, come on. They're going to go into some case law here. I don't know what this particular case was. I'll have to look that up. Yoamos versus World Financial Group. I don't know when that was. Does it have a date? 2021. Yep, I have no idea what that is. If anybody knows what that is, put it in the chat. I'll have to look that up. Affirming the, so they're saying in this particular case, affirming that WFG's agreement lacks mutuality and the center purpose was tainted in an intent to deter World Financial Group associates like Mr. Olson from enforcing their rights under California law. WFG suspends its workers' pay until they sign the agreement and is permeated with one-side and illegal provisions, including the Georgia choice of law provision that this court already found to be invalid, and non-solicit language that this court found to be subject to the per se bar in Edwards. And this particular action, for this reason alone, WFG's motion should be denied. Second, WFG has waived any rights to compel arbitration by initiating litigation of this dispute in 3 courts. WFG filed claims for compensatory and punitive damages against the Olsons in state court based on the same events underlying Mr. Olson's claim in this case, without mentioning any intent to arbitrate the dispute. After the case was removed, WFG amended its pleading to add retaliatory claims for damages against its former co-worker, Cofield, Carter, and Cherwanowski. WFG separately filed a claim splitting lawsuit against Mr. Olson's business, GFI, Miss Olson's business, GFI, in federal court in Wyoming. WFG cannot litigate its own claims while trying to force Miss Olson's claims, which would be compensatory counterclaims in WFG's lawsuit, into arbitration. WFG's extensive litigation activity is inconsistent with its purported right to arbitrate and constitutes a waiver under the FFA. WFG is separately stopped from seeking to arbitrate because granting its motion would prejudice Ms. Olson, who has already incurred costs for discovery sought by WFG and will wait. She's incurred costs for discovery, but yet she just said up here that the discovery wasn't granted. So, okay, and we'll have to re-litigate key legal issues that this court has decided in his favor, including WFG's Georgia case of law provision is invalid, and that its non-solicitation language is subject to Edwards. It's kind of interesting to me, like, I haven't heard the court say anything about that. So it's, I mean, I understand it. It's kind of the same thing, right? When your kid comes to you and says, hey, Dad, can I get a new bike? And you go, I don't know, go talk to Mom. And then they run to Mom and goes, Mom, Dad just said I could get a new bike. It's like the presumptive close, I guess. So they're saying that they've already decided that it was invalid when I haven't seen the court say anything about that. They're kind of just assuming already it's that presumptive close because it was invalid in that particular situation, which was an employee kind of different situation. They kind of just move forward with it. I mean, it's smart. It's smart to do. Third, Ms. Olson's claims includes claims for preliminary injunctive relief. These claims, Mr. Olson's claims against Rob Day, who has not signed any arbitration agreement with Mr. Olson, and the claims by GFI, which also has not signed any arbitration agreement with WFG. Yeah, well, GFI obviously couldn't sign any agreement with WFG, right? They're a business. They would have no reason to do that. But the people running the business have. So I guess, I don't know how you sidestep that claim as well. I understand it's a different entity, but you own the entity, I don't know, are not subject to arbitration under any circumstances. The most appropriate course here is the one that the Olsons have pursued since the beginning, that the 3 pending related courses before this court are consolidated and consistently litigated before this court. For each of these reasons, WFG motion to arbitrate should be denied. And we'll kind of run through this process again. They are a multi-level marketing company that provides financial services, life insurance, variety of wealth strategies, who are encouraged to recruit more agents. At the same time, some of the revenues from the hierarchy goes to pay the upline agents who recruited them. The larger and more successful agents hierarchy, the more compensation they are entitled to receive and the more money they make, right? Yep, same thing if you own a McDonald's, the more your McDonald's sells, the more you make, right? Same exact process. Ms. Olson began working for WFG in 2013. Ms. Olson and all her agents are required to renew these documents annually or be fired. Agents who are tardy in renewing their packet were suspended until the packet was completed. So what are your guys' thoughts on that? Do you guys feel that you shouldn't have to sign? And I mean, it doesn't change anything in this particular situation because she signed the contract previously, which had the arbitration clause and all that stuff in it. But do you think that that's a bad thing that you have to sign a renewal? I mean, I don't know. I don't know how many people actually read these things and kind of go through it, but I don't particularly see that as a bad thing. It only becomes a bad thing when WFG takes actions like they did with Olson and they cancel a program like the hierarchy program, and then you're forced to re-sign that's okay because otherwise you stop getting your paycheck. So that's where I think WFG made a huge mistake on this, is that if things are flexible like that and they can change the rules depending on what's going on, and I don't even see how it helped their case, then this starts to come into question for agents, is that, well, if you can just change the rules and then I'm forced to sign it, I mean, that's a valid point there. I think WFG would have a stronger case if they weren't changing stuff for them specifically, and then I mean, obviously she signed it before things were changed or whatever, but still that's not beneficial for their side necessarily whatsoever. So WFG did not give agents an opportunity to negotiate the terms of any contract contained within the agent agreement. I also don't know how they would be able to do that, or if agents know enough to care. I don't know if anybody really reads it, or it's just like, hey, you need to do this thing, go and sign it, and then you do it. But if they had to negotiate with 70 or 80, I don't know how many thousands of agents they had, and each one wants different terms and conditions and wants this to apply and not to that apply, I don't know how they would, you need your own legal department just to be able to do that on an annual basis. I don't know how that would be realistic, but valid concern nonetheless. The most recent agent agreement signed by her was in 2023. We just looked at that, or at least that part of the arbitration part. We have the other side of that too, which I don't think we'll get to today, but contains a provision that the agent agreed to abide by a separate mutual agreement to arbitrate claims agreement, which is the one we read, included in a nearly 100-page agent agreement package signed by the agent agreement. We will get to that maybe Friday, maybe on Monday, but we'll get to that too. We'll go through that full 100 pages. You can see exactly what's in it. So the separate arbitration agreement states that the parties use binding arbitration as a means to resolve all disputes that may arise out of or relate to my relationship with WFG. So here's going to be her getting into this on why they should not. So Ms. Olson begins to manage Mr. Olson's business within WFG. On or about 2014, Ms. Olson decided to transition from selling insurance products as an agent to managing and running Mr. Olson's business with WFG, which they called Pinnacle Leadership Financial Agency. In this capacity, she was responsible for the day-to-day operations and management of Pinnacle, including event planning, financial management, helping agents become licensed. Basically, she's coming into work in the business. She continued this through 2023. During 2014 through 2023 period, Ms. Olson received a salary from Pinnacle. She was not actively presenting or selling insurance products in the marketplace, and thus she was earning very little commission from WFG, with the exception of commissions from a handful of policies that she wrote for friends, family members, and other. And this is pretty common, right? You can hire your wife. You got to do it for tax purposes. So you do payroll. She gets paid some. You get paid some. You can do all of that through your LLC, S Corp, or whatever it is that you're doing. So that's pretty common. Prior to 2022, WFG recognized the contributions of spouse like Miss Olson, who played supporting roles in the business of their spouses who were acting as agents in 2020. However, WFG stopped recognizing the supporting spouse's role on its website and promotional materials and stopped permitting supporting spouses to be present speech and various WFG conferences. These changes made Miss Olson want to play a more active role in selling insurance products and creating her own source of income rather than play the supporting role. And again, I don't know if you guys, any of you have commented on that, but I would love to know, was that an industry thing or was that just a WFG thing? Because my understanding was the industry changed, and I don't know if it changed on the insurance side or if it changed on the security side. I think it was the security side, from my understanding, was that you couldn't have spouse, right? Because they didn't actually do the work, if you will. Yes, they were behind the scenes, they helped to run everything, but as far as promoting income and stuff, my understanding was the security side got very, very strict. And so since WFG sells security products, they have to abide by that as well, to be fair, kind of to everybody. So from what I remember, that was just kind of a sucky thing that came out. Now, obviously at GFI, if that's a securities thing, then that doesn't pertain to them because they don't sell securities products, so not really a big deal. WFG refused to allow Mr. Olson to sell his code or his income stream, which caused Ms. Olson to want to resign from WFG. So beginning about 2022 and through 2023, Mr. Olson expressed, oh, okay, so good. So this is important here, right? I need to add this to the timeline. So beginning in or about 2022 is when Mr. Olson, when Eric started going to WFG and expressing his desire to want to leave. I would love to know what those conversations sounded like. By that time, Pinnacle had grown considerably, had over 20,000 licensed agents, and was generating at least $100 million annually. To that end, Ms. Olson is informed and believes that Mr. Olson began discussing WFG executives how best to leave WFG, sell, or transfer his code, which was his commissions revenue stream from WFG. So great topic here, right? Like, I would love to know what this conversation was. It could have gone, you know, a bunch of different ways, but I picture two of them in my head. One of them is Olson saying, hey, I want to go do something else. Can I just turn this over to my wife? And I would like to just kind of walk away, doing kind of what Levitan and a bunch of other people have done. But I don't really see that being a possibility the way things have moved, right? Because he could have done that. He could have sold his code number. He could have kind of just walked away from the industry or even started another company. But in that conversation, if it was, hey, I'm going to take all of these people and start a new company, that seems to be more realistic with the way that WFG reacted. And I disagree with the way WFG reacted, but that seems to be more of their stance on it, on kind of what they did, and that's why they terminated the ability for them to be able to transfer, and why maybe they didn't want to buy his code, because that code's value is the clients and agents that are in it. So if he said out loud, I'm going to take all of these people, of course WFG is going to buy the code number because its value is going to drop as soon as it moves over. I used this analogy in the last video. If I'm a CPA and I have a book of business, I can sell that book of business, but if I go in there and steal all those clients back, well, then that book of business isn't worth anything. So I would be defrauding the person who purchased that. So if that was WFG's inclination, that Olson still wanted to keep doing insurance and was planning on taking these people and the clients, then of course they wouldn't buy that code number. But we don't know what that conversation was that happened behind the scenes, but I would love to know. But on or about October 2023, WFG announced that it was changing its policies or rules so that agents could no longer permit or transfer their codes to their spouse. Ms. Olson is informed and believes that WFG's announcing this policy and change is in response to Mr. Olson's request that he permitted to transfer his code to Ms. Olson. And they're probably right on that. That's probably exactly what was happening. Ms. Olson is informed and believes that WFG is refusing to allow anyone to purchase Mr. Olson's code. This would be interesting to find out too. Did they not allow anybody, or did it come with a warning that he's probably going to take all these people and clients, so it might not be advisable to actually buy the code? I don't know. Hopefully that kind of comes out as well. I don't know if they have any of that conversation, but Ms. Olson also learned from various Pinnacle agents at WFG threatened to sue them if they tried to leave. Ms. Olson is informed and believes that all of the revenue for Mr. Olson's business now goes to the people who fired him, including to the defendant Rob Day, who is the agent above Mr. Olson in the hierarchy and therefore earned overrides on all of that business that Mr. Olson's hierarchy generated. So if anybody has this, if you're a GFI person and you have a threatening letter from WFG, email it to me. Just McKenzielong@hotmail. I would love to see that. To me, I haven't seen anything like that, but that would be great for your guys' side and publicity. So if you have that, send it to me. But that's not what I'm seeing. Everything that they post is like, hey, just remember, if you're leaving the company, you're not supposed to solicit people. You're not supposed to churn business. That's not a threat. That's just saying the facts of things. Like if you're speeding down the, if I know you're headed to work today and I know which way you drive and you're leaving the office or the house and I go, hey wife, hey friend, if you're driving down the 215, there's cops over there. You're going to get pulled over if you're speeding. Don't break the law. I'm not threatening you with giving you a ticket. I'm just telling you if you break our contract or if you break the contract of the law in driving, you could probably get in trouble for that. That's not a threat. Very, very different. So based on WFG's decision to prevent Mr. Olson from selling or transferring his code, Ms. Olson decided that she did not want to continue working for WFG. And fair enough, if WFG just flat out said, you cannot transfer your code, you're not allowed to sell it, you are stuck here, and if it comes out that way, then I could see why a lot of this would be justified. I haven't seen that yet, but maybe if that comes out, then maybe it's a completely different story for them. Ms. Olson created GFI to compete with WFG, but she has been impeded by WFG's restrictive covenants. Again, this was her saying that they should be able to solicit people and take clients and do whatever they want because of that 16600. We haven't had to take any shots yet today, but maybe we'll get into that. So October 2023, shortly after Ms. Olson resigned from WFG, she formed GFI to sell insurance products to compete with WFG. GFI is a multi-level marketing insurance agency similar to WFG. To compete against WFG and to grow GFI, Ms. Olson needs to recruit agents and sell insurance products in California. Perfectly legal. Indeed, a primary function of Mr. Olson's job at GFI is to recruit agents in the insurance industry. A primary function of the job of the other agents at GFI is to recruit agents in the insurance industry. That's kind of a misleading word here. Do you see that? Do you see that? It should be into, right? You don't have to recruit other insurance agents. You would recruit agents into the insurance agency. Most of the time you're recruiting somebody who's not already in the insurance agency or in insurance industry, and you would recruit them into the industry, right? You're going to pull them from doing something else to come in to do insurance. But the word they use here is in, meaning their job is to recruit people who are already in the industry. See how they're kind of blurring that line? That's why we need to be able to steal from WFG, because those are people who are in the industry. And GFI's agents' compensation is directly related to the number of downline agents in his or her hierarchy. Now, obviously, you don't get paid to recruit, but if you have a bigger company, then you're going to sell more and you're going to make more money. The agent agreement contains restrictive covenants which have impeded Ms. Olson's ability to compete with WFG. First, there's a non-solicitation provision which purports to limit her ability to contact, solicit, recruit, or hire directly or indirectly any of WFG's current agents or any agent that worked for WFG in the past 2 years. Yeah, exactly. So wait 2 years, and then you can recruit everybody you want. Second, the agreement contains ability to compete. Secondly, the agreement contains confidentiality provision that is overbroad, vague, and constitutes a de facto non-compete provision. As defined, confidential information appears to include the names and telephone numbers of all WFG insurance agents, which I couldn't do this job. Confidential information appears to include names and telephone numbers of WFG agents. Correct. And when WFG asked you for the names and phone numbers of the GFI agents, you told them that they couldn't have it because it was confidential information. So it's weird how it's confidential. It's not confidential if WFG has them. It's confidential if GFI has them. All of which are published by WFG on the internet. Yeah, but you log into that, like your email, although it's on the internet, it's not for everybody to read. You have to log into the system. You have to have access to it. You don't just send a letter for everybody to read from your email that everybody has access to that's on the internet. Yes, you're using the internet to send it, but it's specific A to B communication, or it's supposed to be. Same thing that happens with WFG is you have to log into that system to have access to it. Like I can't just Google Rob Day and have his email address and the office that he works at and that kind of stuff. Although I guess, I mean, people would list it themselves maybe on Google or something. The provision hereby purports to preclude Ms. Olson from contacting WFG agents who may want to join. Yeah, that's what the contract says. You cannot contact, solicit, recruit, or hire directly, indirectly any of WFG's current agents. Go recruit the other 300 million people in the United States. Just leave WFG's people alone, and then you don't break your contract. This definition renders the confidentiality provision an effective non-compete provision because it purports to include the names, telephone numbers, and contact information of WFG insurance agents. Indeed, the definition even appears to include contact information for the people of whom Ms. Olson had pre-existing relationships, such as her friends and family members who worked at WFG and may want to join the GFI. The provision applies in perpetuity violation of Section 1. There's your shot for the day, 16600, and is unlawful. So again, they're saying that because you can't recruit WFG agents, you simply cannot operate. There's no way to operate your business in the insurance industry unless you can steal WFG agents. It's the only way to be able to do business. Otherwise, it's a non-compete, and there's no way you can survive in the industry if you can't recruit WFG people. There's plenty of other companies that feel that way too, so it's not. They're definitely not the first, probably not the last, and not the only, for sure. Most of the copycat companies cannot recruit people. They have to go after agents who are already in the industry, which makes sense, right? It's a faster process. It's much easier. It's why the anchor leg strategy is like so divisive. If you can just steal agents who are already doing well, your income jumps up tremendously. Why go through the process of getting somebody licensed and having to teach them how to do the business and how to sell a policy and how to build a team and to train people? Like that takes years of process to take somebody from nothing to something in our industry. Why? You can skip that whole process and just recruit somebody over directly that's already doing well. It's way faster. I mean, I understand why they want to do it. I just don't necessarily agree with it. I mean, I think that's unfair. I get people coming to me all the time. Hey, should I still join GFI? And my answer is always, if they're talking to you, go talk to them. If you don't like it, try another company. It's like so easy to recruit people who are already in the industry if you're willing to just be a little bit shady about it. And I understand there's like a confidence thing with that, right? Like people would probably do better if they were with me than with somebody else or whatever. But like, I don't know. Don't we have an agreement with each other that if they're already recruited with you, that they go through with you? I mean, I don't know. Non-disparagement provision that is overbroad, vague, and constitutes an effective non-compete provision in that if you can't talk bad about the company, how can you start another company? You have to be able to badmouth and lie about WFG to start your company. I mean, that's just business, right? Like if you can't lie about Thali coming over and you can't lie about WFG going out of business and you can't lie about those things, well then how are you supposed to ever start your own company to compete with them, right? So you have to be able to do that. This clause, sorry, that's my sarcasm if you can't tell. So this clause purports to preclude Ms. Olson from doing anything that will damage the business, good name, or reputation of WFG, its affiliated company, respective officers, directors, and employees. Yes. Now, I understand you need energy. I understand you need momentum. I understand you need to convince people to leave one company and come to another, but you don't have to lie about it. You don't have to make up stories. You don't have to talk bad about a company. You can talk good about yours. I understand it's way easier, right? Like you're selling a policy. It's much easier to badmouth a company and a person to sell your product and service. I understand that, but you're also not supposed to do that. You can not talk bad about that company and talk well about yours and convince people to come over, but apparently you cannot start a new business or a competing company if you can't badmouth the old company. This restriction is so broad that it would effectively preclude Ms. Olson from saying anything bad about a competitor. Yeah, you can say truthful stuff, which prevents her from competing against WFG in its entirety. So further, the phrase doing anything that will damage the business is so broad that it includes any act of competition, such as selling a policy to one of WFG's customers or saying something to promote GFI. I guess, I think you're stretching, but that's fine. Ms. Olson has been harmed by WFG's restrictive covenants on the other and other agents. WFG threatens to sue them if they join GFI. Many WFG agents are also subject to the same restrictive covenants that are contained in this agreement that Ms. Olson has signed when she joined WFG. Ms. Olson and GFI are informed and believe that there are many WFG agents, especially those that previously were part of Pinnacle, who wish to join GFI. Nice that they kind of put this in here too, right? Yeah, they were part of Pinnacle, but they were also part of WFG, who wish to join GFI. Ms. Olson and GFI are further informed to believe that many of these agents are fearful that WFG may sue them for violating the restrictive covenants if they leave WFG and join GFI, because fighting a lawsuit against WFG would be too costly even if they prevail. This atmosphere of fear, uncertainty have impeded Ms. Olson's ability to hire many agents who are affiliated with WFG. My understanding is Olson was telling everybody that he was going to pay for all of their legal fees, right? So why would they be afraid of legal fees? And it's only legal fees if you steal. I mean, to break it down, like you're allowed to leave one company and go to another one. You can do that all day long. You just can't steal people from the former company. So I mean, I understand it sucks. I understand it may not like it, but that's kind of what you're agreeing to. So in addition to include non-solicitation provision in the agreement with its agents, WFG and its executives and agents have also repeatedly threatened agents who are contemplating joining GFI. Please, like at this point, you guys have to send me some of this communication. Please, if you have it, email it to me, get it to me somehow, Instagram, whatever, Facebook, whatever. I need to see this. Are you guys actually being threatened? I would love to know. Is WFG saying, look, if you don't produce for WFG and you decide to leave, we're going to sue you for going to GFI or competitor? I've talked to, I don't know, probably 15 people in the last month or so since this all started, 2-3 months, that have left WFG, and not a single lawsuit. It's weird. They didn't go to GFI necessarily, but they went to other companies, they made other decisions, maybe got out of the industry. None of them have been sued, so it's kind of weird, or threatened. They didn't get a single email or text message or nothing, so weird. WFG and Mr. Olson file related actions arising from the parties' disputes. On January 25th, WFG filed an action against Mr. and Ms. Olson in Santa Clara, seeking damages. We'll kind of go through a bunch of this. We're repeating a lot of this stuff. On January 26th, she started her company GFI, filed an instant action against WFG in the Northern District. WFG also initiated an action in the United States District Court of the District of Wyoming against GFI. All 3 Northern Districts of California cases have been related and are now pending before this particular court. This court decision's WFG motion for temporary restraining order and grant. Wait, did it? Okay, am I losing my mind? Denied the motion for the temporary and granted WFG's motion for expedited discovery. I thought they just said that they denied the discovery. Maybe they're talking about in the other court, but they just said that they had denied it. Now they're saying that it was granted. Okay, action. WFG has actively persuaded discovery pursuant to that order and has served document requests and interrogatories on both Mr. and Mrs. Olson, served several third-party subpoenas. I'm excited to get those back and started noticing and scheduling third-party depositions. The Olsons have responded to those requests and served document requests and interrogatories on WFG. The parties are negotiating the terms of the protective order and preparing the documents. On February 29, 3 days after filing motion to compel arbitration in this action, WFG filed a First Amendment complaint against the Olsons. In the WFG action alleging inter alia, mirror images, claims of tortious interference, unfair competition under this section of 17200, and seeking punitive damages. Also added claims for monetary damages against the former agent Cofield, Carter, and Chiranowski. The party seeking to compel arbitration bears the burden of providing existence of an agreement to arbitrate. Yeah, they have one. Okay, bunch of case law. WFG's arbitration agreement is unconscionable. So WFG's motion to compel arbitration fails because WFG cannot establish the formation of a valid contract to arbitrate Ms. Olson's claims. So I guess the entire agent agreement is invalid because it's not a valid contract. As Judge Chen in the Ninth Court found regarding an earlier version of WFG's arbitration agreement, the arbitration agreement is unconscionable because it lacked mutuality and the central purpose was tainted with the intent to defer excuse me, World Financial Group associates like Mr. Olson from enforcing their rights under the California law. I guess I'll have to go back and look at this one if I can find it. Under California law, a contractual clause is unenforceable if it is both procedurally and substantively unconscionable. They found in these other court cases, the arbitration agreement is procedurally unconscionable. More court cases. The arbitration agreement is procedurally unconscionable. Procedurally unconscionability turns on adhesiveness, a set of circumstances in which the weaker or adhering party is presented a contract drafted by a stronger party on a take it or leave it basis. I mean, that sounds similar to kind of what WFG has, if you have to sign that age agreement or not. I don't know. I guess that might fall into that. First, the arbitration agreement is a contract of adhesion. As with prior agreement, invalidated by that particular code against WFG, required agents to sign an arbitration agreement on a take it or leave it basis without the opportunity to negotiate, making it a contract of adhesion. Which is interesting though, because when you work for a company, for you to have the job, you have to sign the arbitration agreement. When I worked for the county, you couldn't dispute any of that. That was part of your onboarding contract. When you're an engineer and you're working for the government, they have that in there. It's not a, well, I can take the job but not do the arbitration clause. That's just part of the business. That's part of the job offer, if you will. Basis signing up for agents creating a contract of adhesion. Arbitration agreement is at least minimally procedurally conscionable if it is a contract of adhesion. More case law. Agents who took too much time to consider that year's terms risk pecuniary harm, as WFG agents were suspended who were tardy in reviewing their ticket. The restrictive covenant of WFG's employment agreement and the nature of WFG's business, a recruitment-based structure in which agents build and maintain their income streams over time, preventing users from shopping around, meaningfully withholding consent before accepting the terms and conditions. Court find unconscionability. Interesting. Okay. Which I don't remember. Do you guys remember? Was that in GFI's contract or not? I got to go back and read GFI's contract. Because I thought they also had arbitration in there. So again, and maybe potentially another thing that is for me but not for thee. Third, the arbitration agreement is unfairly surprising. Surprise involves the extent to which the supposed agreement terms of the bargain are hidden in a prolix printed form of the drafted by the party seeking to inform the disputed terms. More case law here. As with prior WFG agreements, that was invalidated. Surprise is manifest here because a reader seeking to make sense of the arbitration provision would have to flip through a separate document in order to understand the extent to which they would be bound. It's a surprise if there's 2 pages, is what they're saying. So this must be California law. This has to be in California, because if it's 2 pages, it's too big of a document. And you might be surprised if you didn't flip the page, you would be surprised to find all the stuff that's on the other page. So you can't be bound by that if you have to flip through a separate document in order to understand the extent. Gotcha. On the one hand, the agent agreement at the front of the agent agreement packet prompts to bid signatories to separate arbitration agreement. Agent further acknowledges agent's understanding to agree to the separate standalone mutual agreement arbitration claims agreements that follows this agreement. Okay, I guess I kind of see what they're saying in that in the agent agreement, which we'll go through, you're basically saying that I agree to arbitration, and then it's on another page that you have to go search for is the arbitration agreement. So I apologize, I was being a little facetious earlier there, being multiple pages. But I guess if you sign on one page, one part, and then you have to refer to another document, I guess I could see how that would be challenging to have to read the whole contract. However, the arbitration agreement is tucked away near the end of the packet between the financial authorization forms. Conversely, the arbitration agreement requires arbitration of all disputes that may arise out of or relate to the agent's relationship with WFG, but the Georgia choice of law provision WFG purports to impose on those disputes is located in the back of the agreement and at the front of the packet. This manipulation of the presentation of terms to obscure them significance further supports the finding of procedural unconscionability. Interesting. Okay. So how would you do that in a contract? Every time you get to a bullet point that refers to something that's long, you have to do it right then and there. So to get to all of the signing in a contract, because that happens all the time. Like, I agree to these terms and conditions. See page 57. Turn to page 57. Here's all the terms and agreements with that. Like, think about any time that you agree to terms and conditions when you download a new program, or you install something on your computer, or you open up a packet. Do you read those terms and conditions? No, right? Like, never, not once in my life. It could say I have to give up my wife and my kids, and I would never know. I would just agree to it. But also, if it was all in one page and I had to scroll to the bottom of it, I would probably just scroll. I'm sorry, I'm just being honest. I'm a human being. I would probably just scroll to the bottom anyway, and it wouldn't make a difference. But they're saying how it's stacked in the deck makes a difference, that you can't agree to it on one page and have the rest of it being on another page. The arbitration agreement is substantively unconscionable given the extent to which the arbitration agreement is procedurally unconscionable. Only minimal substantive unconscionability is required to render the arbitration agreement unenforceable. So I don't know. I mean, it sounds like, at least to them, it sounds like they have a valid argument here if previous California case law has had issues with these in the way that they've done it. So it sounds like it's almost becoming like New York in a way. In these particular states, you have to have an entirely separate agent agreement that's different than the other states because they do everything very, very differently. So the arbitration agreement incorporates a non-solicitation and choice law. So again, they're saying it should be found out that this court has already found to be illegal. Different situation, but they're saying that it's illegal. So again, they're trying to throw out the whole agent agreement altogether. Violation of the section 16600, another shot for you. This count has also held Georgia law cannot apply to claims arising from the, operative facts at issue here, namely WFG's unlawful enforcement of illegal and oppressive non-solicitation provisions. They're going to go through a bunch of case law about that. These provisions violate fundamental policies of California. 16600, another shot. Trying to evade 1600, another shot. Choice of law provision violates California's public policy. Bunch more case law on that. We've gone through a bunch of these at nauseum. The arbitration agreement incorporation of these two onerous and illegal causes alone renders arbitration agreement substantially unconscionable. The arbitration agreement incorporates the agent agreement's one-sided provisions. So they're saying that but I don't know how you would, like, imagine going to a job, right? You get your onboarding packet, they hand it to you, and you go, hey, I really want this job, I agree to everything else, but I don't agree to this arbitration aspect of it. Are they going to sit there and go, okay, well, for our other 10,000 employees, this is what we have, but for you, we'll set this aside and you can have the job? I don't know. I doubt that. That agent agreement contains several one-sided provisions, rendering the arbitration agreement substantially unconscionable. First, WFG has given itself the ability to unilaterally amend the terms of the agent agreement. Fair point to them. Fair point, like point for GFI. If they can just come in and change the agreement whenever they want, they can get rid of certain provisions, your ability to be able to sell or do the hierarchical transfer to your spouse. Fair point. I think they've kind of brought that on themselves, rendering the arbitration over the agent agreement unconscionable, and more case law about that. This particular section allows WFG to terminate the agent agreement at its sole discretion without notice to the agent. Agents do not have commensurate power. At best, they provide notice to their intent to end their agent agreement. Sole discretion without notice to the agent. Only if you're breaking the contract or the law. Right? Like, I've never heard of them just coming in terminating. So, oh, you're a redhead? Oh, we don't like redheads. We're going to terminate you. But I don't know. Anyway, whereas WFG purport to limit its ability in the event that it terminates the agent agreement, WFG purports to hold Mr. Olson liable both for either party's termination of the agent agreement and for any loss that WFG sustained as a result of acts of Ms. Olson and any of her downline agents to be required to identify and hold harmless from that loss. Thus, any arbitration Ms. Olson would be exposed to liability for all manner of damages and in claims, while WFG is insulated from damages arising from its own decision to terminate Mr. Olson agreement. And fair point. This is kind of what we talked about in the beginning, that in arbitration, usually you're not able to ask for damages. It doesn't mean it doesn't happen, it's rare. So fair point on that as well, in that, but that isn't that why it goes through arbitration first? And at least from what I've seen, the damages have occurred more so on WFG, at least because this is a GFI lawsuit, right? This isn't a Eric Olson lawsuit. Eric Olson would be the one with damages, but she's saying that the company, GFI, has had damages arising from this decision, from her termination. Yeah, I don't know. Third, the agent agreement requires agents to cooperate fully and provide assistance to WFG in the investigation and resolution of any complaints that may be brought by or involve the agent, but does not require the same of WFG. The one-sided provision unfairly favors the interests of WFG over agents and set up WFG prevail either on the agent's claim due to the agent's cooperation or on unfair breach of contract claim due to the agent's refusal to cooperate. I felt this way when I had to go through arbitration. It felt very one-sided, just to be fair to the Olsons on this aspect. Arbitration felt very one-sided. Like, it felt like I was talking to an employee or employee of the government when I was talking to the arbitrator. Basically how it felt. So understandable as far as their concern of it not wanting to go that way. The arbitration agreement also becomes fee-shifting rules that seek to subvert California's protections for workers in favor of WFG. It provides that the arbitrator shall award reasonable fees and costs or any proportion therefore to the prevailing party. Losers pay provision, which is kind of similar in a lawsuit a lot of times. It doesn't mean the judge will grant it necessarily, but they can ask for damages and lawyer fees and that kind of stuff. This is unconscionable under California law because the provision creates WFG workers take a greater financial risk in arbitrating claims than they would face if they were to litigate those claims in federal court. California hates business. Is that true? Like, California hates businesses, right? That's kind of funny. Okay, more case law. Some of the statutes under which Mr. Olson is suing, for example, another shot, contain one-way fee shifting to protect workers to encourage them to invalidate oppressive employment. Oppressive. They are the oppressed. I hate that. Okay. Punishing a worker for bringing such claims defeats the purpose of these statutes. Ms. Olson would not be at risk of paying WFG's fees if WFG prevailed in this litigation. According to the arbitration agreement, losers pay provision is unconscionable. The arbitration agreement unlawfully prohibits public injunction relief. We're going to kind of skip through these. We're getting pretty fast. You can go back and read it. It's on the local site if you want to do that. The arbitration agreement contains a one-sided provision. We've talked a lot about that. WFG has waived any rights to arbitrate by litigating substantial issues in this dispute. They're saying that it's beyond the search of arbitration. Although in the arbitration paperwork it says that it goes through arbitration first, but they're saying that there's too much stuff in there. WFG's conduct constitutes waiver under the FFA. Federal law applies in determining waiver under FAA. The Supreme Court resolved a circuit split in the standard for waiver and held that prejudice is not a condition of finding that a party waived its rights to stay litigation or compel arbitration under this act. Thus, under federal law, a party waives its rights to arbitration when only two conditions are met. So finally, we got here, okay? Knowledge of an existing right to compel arbitration, and two, intentional acts inconsistent with that existing right. The first prong is undisputed, as WFG is aware of its own contract. As the second prong, there can also be no dispute. WFG's initial complaint against the Olsons included claims for money damages and injunctive relief without any mention of arbitration or WFG's arbitration provision. Then, after moving to compel arbitration, WFG filed an amendment complaint in the WFG action, again seeking monetary damages and injunctive relief against Ms. Olson. Each of these actions is inconsistent with the right to arbitrate and supports waiver. More case law here. WFG has done even more. Rather than initiate arbitration of the disputes arising from the party split, WFG has engaged in a flurry of litigation across 3 courts. First, WFG filed the WFG action in the state courts based on the same events underlying Mr. Olson's claim in this case without making a mention of its supposed right to arbitrate. That act alone constitutes a waiver because like in this particular case, WFG made no mention of an intent to do anything other than seek damages and other relief in court. Moreover, if her motion to dismiss in WFG action is denied, Ms. Olson will be required to assert her claims in this action as compulsory counterclaims in WFG's actions. Second, after moving to compel the arbitration in this case, WFG has filed the First Amendment complaint on him. So basically they're just listing that these things are going to be outside of the arbitration. Moreover, WFG added regulatory monetary damages claims against other former WFG agents subject to the same arbitration agreement as Ms. Olson as defendant in action rather than purpose those claims in arbitration. So that becomes an interesting question. I don't know the answer to this. Any of you lawyers out there maybe can help with this. But would they still go through arbitration, right? Because WFG's claim is more about fraud, I would think. Like fraud and stealing agents and clients where fraud starts to get involved using client information, that kind of stuff. Would that still go outside of arbitration, or do you have to arbitrate that first as well? I don't know. Without disclosing any intent to arbitrate in court, WFG obtained expedited discovery from the Olsons and various third parties. This too is inconsistent with its purported right to arbitration. Meaning, my question here being is, could you arbitrate the employment aspect on one side, whether termination was valid or not, and then legally go through the fraud claims on the other side, because they're kind of two different issues, right? Whether you were terminated legally or not, handled in arbitration. Then if there's fraud that was found in taking people's information, moving clients over, possibly churning, that kind of stuff, that would be handled outside in the court of law. That's not going to be an arbitration aspect. So does it make sense to file multiple cases? Or would you go through arbitration, find the termination was legit or not, and then go into extra things outside of that if there was fraud and stuff involved? I don't know. As evidenced by WFG's whirlwind of litigations against the Olsons and the former agents subject to arbitration agreement, WFG is actively disregarding its purported right and obligation to pursue arbitration in its own action while seeking to enforce arbitration on Ms. Olson's related action. Excuse me. This satisfies the second prong of the waiver. WFG isn't stopped from compelling arbitration because it would cause prejudice on Ms. Olson. We'll go through some case law there. If WFG's motion is granted, Ms. Olson will be required to litigate overlapping issues in two drastically different fora. Fair point, right? Because she would be going through the arbitration on one side, then through the court of law on the other side. But for two different issues. At least that's how I see it. One issue is, were you terminated with and without cause? And what should happen with that? Meaning, should you still get some kind of benefit from that? He owned the code number of Rob Day. How do you get paid out on that? I think that would go through, that wouldn't be a law thing necessarily. I think that would be through arbitration on how much damages you could get or what you should get as far as your income that was left. And then the other side of that being the legal aspects, potential fraud, that kind of stuff. But so I can see why it would be split in two, but I can see her point of it also wanting to only have to fight in one area as well. Goal of effective dispute resolution will be to cause prejudice on Ms. Olson. More case law. Here, rather than litigate the parties' minor claims in one consolidated litigation, WFG seeks to force Ms. Olson into litigate the parties' claims, which arise from the facts in both court and in arbitration. Thus, Ms. Olson would be forced to re-litigate the enforceability of WFG's restrictive covenants under Take a Shot, even though this court already has ruled that this is subject to the court's Supreme Court ruling in Edwards, and thus an invalid restraint on trade. But I think they would be talking about two different things. I can see why she wants to put them together, though. It makes sense, right? Like, I was wrongfully, right? Because if the claim for the 1600 allows them to do whatever they want, then they were wrongfully terminated. You see what I'm saying? So if 166 applies, and we're allowed to take agents and clients and disparage the company and take confidential information, people's names and phone numbers, if we're allowed to do all of those things, then in actuality, I was terminated without cause. So I did all of these things that are against my covenant with WFG, my agreement with WFG, but if the court finds that those are not legal, then they could also potentially get everything back and be reinstated, I guess, with WFG for being terminated without cause. So wow, that would be a complete turn of the coin if that happened. Imagine Olson getting his code number back while he's actively stealing agents and clients and now has access to everything again. That would be a huge win on their side, and completely against WFG, that they could not only get their position back with WFG, but still have the company that they're actively moving people over to. That would be fascinating. Similarly, Mr. Olson, a California resident, will have to relitigate the enforceability of the agent agreement in Georgia's choice of law provision on its claims, allowing WFG another chance to litigate these key legal issues that the court decided Ms. Olson's favor is insufficient to proceed. Is sufficient to establish prejudice. All right, we're almost there, guys. It will also prejudice GFI, whose claims in the GFI action arise out of the same series of transactions, creating a possibility of possibility of conflicting rulings in common issues. Like if the court finds that they were terminated incorrectly, right, because of California's code, but then on the other side in Georgia they say that they were terminated correctly, there's going to be a conflict in those rulings on common issues, which would not be necessarily helpful for them, especially since California is going to be more beneficial for them with that 16600 provision that they're able to kind of refer to. They don't have that in any other states, so it's going to be unfavorable for them to do this anywhere else. GFI's claims, because they literally would have no case. Like if it wasn't for California, this case would not exist. It would be clear as day. You took clients, you took agents, you had confidential information, you badmouthed the company, 100% you lose this case, all 49 other states. But because it's California and the 16600 might apply, well, maybe you can do it in California. Further aiding to Ms. Olson's prejudice, the parties are already engaged in mutual expedited discovery in the WFG action. As the Ninth Circuit noted, engaging in discovery can weigh towards finding a prejudice. Ms. Olson has had to respond to document requests, interrogatories, several document requests and interrogatories on WFG, and collected documents for production and prepare, third-party depositions. Ms. Olson has already incurred costs to engage in the expedited discovery at WFG's request, including document discovery and multiple depositions. Having taken action inconsistent with its purported right to arbitrate, that would cause prejudice to Ms. Olson's to arbitrate. WFG is stopped from now seeking to compel arbitration. Ms. Olson's requests for preliminary injunctive relief are exempt from arbitration, even if WFG's arbitration agreement is enforceable. WFG's motions to compel Ms. Olson's claims to arbitration is premature and improper. Ms. Olson has told WFG and her complaint makes clear that she intends to seek preliminary and permanent injunctive relief from the court from ongoing irreparable harm WFG is causing her, because they won't let her just freely take people and just step aside, then it's causing her harm. Section 2 of the arbitration agreement, which provides a court may grant interim, temporary, preliminary injunctive relief to preserve the status quo of prevalent material, imminent harm pending arbitration. The complaint further describes the irreparable injury to Ms. Olson from WFG's actions. Thus, at minimum, WFG's motion should be denied pending resolution of Ms. Olson's request of preliminary injunctive relief. Excuse me. And they want them to deny the motion to compel arbitration. So, your guys' thoughts on that? Tell me how you feel about it. If you feel like it should move to arbitration, it feels like anywhere outside of California, they have a great case, but this is happening in California, so obviously things are very, very different. Hope this was helpful for you in understanding some of that. We didn't get to the reply of what WFG's final response is to that. We also didn't get into the agent agreement, that 100-page agent agreement packet. I think is massive. To be fair, the contract is like 20 pages. But the entire access that you have once you get into the system, I guess the entire agent agreement packet is fairly large. So we'll go through that another day as well, probably on Friday. So anyway, appreciate you guys. If you want any of these documents, don't forget to go over to McKenzieLong.locals.com. A lot of that stuff, as much as I can provide at no cost. The court documents I have had to put behind the firewall because people have been doing stupid stuff with them, and I pay for them. I'm probably, I don't know, $1,000 into court documents for downloading all this stuff. You have to pay per page for everything that you download from their website. So appreciate all of your guys' support over there on Locals, and I hope you guys have a fantastic day. I will see y'all on Friday. So take care. Bye.